Michael, you teach international arbitration at Tokyo University, and you served as an arbitrator in ICC, JCAA, and Swiss Arbitration Center cases. For business people who've never dealt with arbitration, what's the one thing they get wrong about it?
I remember when I moved to Japan with some experience in arbitration and was involved in giving talks and educating other lawyers, students. So my general impression was people who have heard about arbitration here in Japan had the impression that arbitration is simply expensive. It's too expensive, which I understand to some extent. It could be true if comparing with the fees that are paid to Japanese courts. But if we think of the advantages, such as the length of the proceedings and the fact that an arbitral award, which is basically the result, the judgment, the end of the arbitration process, is basically enforceable in the moment it's rendered, and it's not appealable. Of course, there are some mechanism to attack the award, but in general, we can save a lot of time, and time, as we know, is money. So I think the general perception, maybe it was 10, 15 years ago, was that arbitration is expensive, which I think it's a sort of a misconception.
And is it generally faster than going to court, or about the same amount of time?
Considering what I said, that you don't have the possibility to appeal an arbitral award, which is the decision of the arbitral tribunal, it is faster. It is generally faster. Most of the arbitration institutions have listened carefully to the criticism from the public, from the users, and have implemented fast proceedings. For example, JCAA recently introduced the super fast procedure where the tribunal, or the sole arbitrator, is obliged to render the decision within 3 months. 3 months from the moment that he or she is appointed, which is probably much faster than any case would finish in a Japanese court or a court of any other jurisdiction.
That sounds a lot faster.
Yeah. So for certain amounts in disputes, 3 months. If the amount is larger, at 6 months. In average, I think we are maybe around 1 year.
Well, let's talk about what it actually is. Let's say I'm an American company doing business with a Japanese partner and things go south for whatever reason. We hit a problem. Can you walk me through in plain language what arbitration actually means and how it's different from going to court?
I say it's not very, very different from someone who is looking from outside. Though, looking from outside, the great difference is that some people may not be able to see that the arbitration proceeding is going on. It's arbitration enjoys a high degree, I would say, of confidentiality.
And a court case would be public.
And a court case would be, in general, public. So that means 24 hours later, all the documents that have been filed are generally available to the wide public. So in arbitration, we don't have that. The filing happens typically with the arbitration institution, and it's only institution or the parties that at that time are aware of the proceedings. The hearings take place behind closed doors. The hearings are not advertised. Usually hearings take place in private rooms, be it in hotels, in law firms that have the infrastructure, or designated arbitration hearing centers. There are many of them in the world, but some institutions, some jurisdictions have provided such facilities.
And we have one in Tokyo, right?
We used to have one in Tokyo, not anymore.
I've seen contracts with arbitration clauses that say ICC arbitration in Singapore or JCAA arbitration in Tokyo. what's the difference, and does it matter?
Yeah, it's interesting actually. Students all often ask me about that. How it's possible that you have different jurisdiction, different languages, different institutions involved, and not, for instance, let's say Japanese language arbitration seated in Tokyo, and the JCAA, which is the Japan Commercial Arbitration Association, administer the case. Uh, I like to compare this with when you go to a restaurant and you order your food. So if you go to court, you basically get the course menu. You don't have a lot of flexibility in many restaurants to swap things or skip things. You just have to eat what you given if you like the course. On the other hand, if we think of arbitration, it's like eating a la carte, where you choose the dishes you want to have. You can skip some. You can say, I don't want to have oral hearing because the case seems to be document heavy, and we don't have witnesses, so we can omit this whole part. You can decide the length of the proceeding. You can choose which element you want. You can swap. You can choose the language you want. You can go to a most convenient venue for the parties. And I think the big feature, this is answering your previous question, is that the parties can have the possibility to choose the decision maker. They can decide who should decide the case, just the arbitrator.
So it's easier than trying to choose a judge.
It's easier than trying to choose the judge, because if you go to court, you don't have any influence on who will be your judge. The judge is assigned to you by the court, and you may be able to go against the judge if there is any appearance of bias, but you don't have any tools that will allow you to be part of the process of selecting the judge.
So, following up on my hypothetical, if I'm an American company, should I push for arbitration in the US, or is there an advantage to having it in Asia?
Well, it depends. It depends. I think we generally have the impression that the home advantage is a significant one, and that if I have the arbitration being seated, let's say in my surrounding, I may have better chances. I think in general, the issue with the venue or the seat of arbitration, as we call it, is that if the arbitration is seated, let's say in America, as you said, you will have then perhaps more likely an American arbitrator who may be more likely would apply the law the way he learned it. If you go to Japan, you may likely have civil law arbitrator who would then structure or propose to the parties to structure the proceedings the way a civil law practitioner would do it.
Just based on your experience as both an attorney and an arbitrator, what's the biggest mistake you see companies make when it comes to arbitration?
I think that in general, we see a lot of poorly drafted arbitration clauses, and I think this is to start with. I do not know where they come from, how they were drafted, why they were the way they are, but we see a lot of disputes on whether the arbitration clause is valid or not. And here, when I organize workshops, when I talk to students, I usually say, don't try to reinvent the wheel. The arbitration institutions typically provide so-called model clauses. Stick to the model clauses. Think of every single change that you are considering with respect to the model clause. Why am I doing that? Is it necessary? Does it really add value? Don't try to swap things, change things without carefully taking into consideration what consequences such a change or swap may have.
Once you have a fully executed contract, can you fix a badly drafted arbitration clause, or are you stuck with it?
So you can fix it since arbitration is driven by the so-called party autonomy. If both parties agree, they can fix it. We see occasionally that parties, after the dispute arises, decide, for example, to submit the dispute to arbitration, despite the fact that the contract was pointing towards or providing for a court litigation. So if parties agree on that, they can fix the mistake. They can move the venue. They can change the language. They can change the institution if they agree. If not, it may be difficult.
Let's say I'm reviewing a contract right now with my team, and we're deciding whether to include an arbitration clause. What questions should I be asking to make that decision?
I think for the counsel who is drafting the arbitration clause, it's important to be able to picture a potential dispute. And although I promote arbitration, I teach arbitration, I'm passionate about arbitration, I don't necessarily say that arbitration is the only and always recommendable method of dispute resolution. There could be cases where going to court may be more efficient, faster, cheaper, and simply leading to same results. That's why it's very important to understand what dispute with which features may arise between the parties. You know that domestic arbitration in Japan is not really often used. So the experience of domestic arbitration is also very, very limited in Japan. In such case, perhaps advising or pushing through to have an arbitration clause could be an overkill.
Can parties agree to change the arbitration terms after a dispute arises, or is it too late?
Party autonomy. Parties can do whatever they want. It's again, if I bring my example with going to eat in a restaurant a la carte, parties can, before the dessert arrives, to raise the hand and say, like, please, can you put some extra whipped cream on the top, or despite not having ordered, parties could add a sorbet before they move to the main dish. So it's possible to make changes at basically any stage of the proceedings. Of course, it's the tribunal that is in the driver's seat of the proceeding, but the tribunal is acting based on the parties' consensus.
So both parties don't necessarily have to agree on everything. The tribunal can decide.
If the parties disagree, then the tribunal typically decides. But if we have an agreement between the parties and this agreement does not go against the mandatory laws at the seat, if the agreement doesn't go against like fundamental principles, for instance, equality between the parties, it should be possible for the parties to make changes to the terms of the arbitration.
I guess that means it's very important to choose your arbitrators wisely.
It's very important to choose the arbitration wisely. There are a lot of discussions about, what is better for which situation. Is a civil law background of an arbitrator better for civil law parties, or is a common law background of the arbitrator better? I think experienced arbitrators, they can think themselves into the parties, in what the parties really want. So,
Final question. You teach this at Tokyo University to future lawyers. If you had to give one piece of advice to business leaders about international arbitration, what would it be?
I think arbitration is a dispute resolution method, and I think for business people, for business leaders, it's not choosing the dispute resolution method, which should be, I say, an achievement. That the achievement should be if the leader is able to avoid a dispute. And I think perhaps for us lawyers, practitioners, it's not it's not advantageous if there are no disputes. But I think from the business perspective, navigating through the daily business without having a dispute arising is a virtue, I would say.
Great. Michael, thank you. For anybody who wants to learn more about international arbitration or needs help with a cross-border dispute, Michael practices at Nozomi Sogo here in Tokyo.
Thanks for watching.